Welcome to LKG Law, PA, an elder law firm with over 30 years of experience focusing on our elderly and disabled populations to address their special legal and financial needs. Hello, I am Lisa Klein Goldstein, principal of the firm. I am an accredited Veterans Administration attorney. Thank you for taking a moment to learn a little something about a potential tax-free gold mine that may help someone you know who served in World War II, Korea, or Vietnam, who is 65 years or older, and who is in need of long-term care. This government benefit is called Veterans Improved Pension with Aid and Attendance, or Aid and Attendance for short. This benefit has been available to vets and their spouses, sometimes even their children, since the American Civil War, when Abraham Lincoln instituted it for those who served in the bloodiest conflict that this country has ever fought. When a vet or a spouse of a vet meets certain physical and financial requirements, he or she can receive tax-free dollars to offset the high costs of their home care, assisted living care, or even nursing home care. Let's go through the basic qualifications. First, the vet must have served 90 days in any major armed services. Unfortunately, reservists and National Guard personnel do not generally qualify. Note that one of those 90 days must have been served during a recognized war time. Most people don't realize that the recognized time span of any of the wars I previously mentioned is generally greater than what civilians consider the actual length of that war to have been. So just because you may have started to serve after August 15, 1945, when the Japanese surrendered, for example, does not necessarily preclude you from obtaining aid and attendance. It's important to verify the actual dates of conflict that have been established by Congress. Also be aware that the vet could have had a desk job stateside. Active combat is not the criteria. Rather, military service is. Wherever the vet was assigned during that period is what matters. Secondly, the vet must have received a discharge other than dishonorable. If a vet is considering applying for any type of VA pension, please be sure to have him or her obtain their discharge paperwork, known as the DD-214. The DD-214 will list right on that form the particular type of discharge and the dates of service. Remember, no dishonorably discharged vet is ever entitled to aid and attendance. Third, the vet must be over the age of 65 and minimally have limited income. The VA recognizes that a vet should be entitled to a certain base income in which to live. So if the vet's non-VA income is below the base rate of approximately $1,300 per month, the VA will make up the difference between the vet's current income and the pension base rate. Now, the VA considers that any vet over 65 is potentially eligible for a base pension. They also recognize that the historical basis for this pension is to assist vets who, because of their old age, 65, and infirmity, may require more money to survive than just the base pension. But the VA pension was not designed to simply subsidize older vets who still are capable of taking care of themselves. So in order to obtain additional funds for older vets, the VA Improved Pension has developed two more tiers of benefits for those situations where a vet's medical expenses are so high that most or all of his income is used for unreimbursed medical expenses, and not just for daily living expenses like cable TV or food costs. These two tiers are closely related. They are housebound and aid and assistance. For purposes of this video, think of them as aid and attendance, as it is often easier to obtain this benefit. Plus, aid and attendance offers a potential higher award than housebound. An example of how this might work is in order. Meet Joe, 83, a Korean War vet, who is married to his bride of 45 years, Shirley. He has just had a stroke that has left him partially paralyzed on his left side. He and Shirley want him to stay at home. He is now in a rehab waiting to come home. The family knows that he will need a full-time aide since Shirley is too frail herself to assist Joe with many of his personal needs, like bathing and transferring from bed to chair. After analyzing their income and reviewing all of their medical expenses associated with Joe's situation, and to some degree Shirley's medical situation, it becomes apparent that Joe and Shirley need to use all of their income to pay for Joe's care. The VA, if Joe meets all of the eligibility requirements, will likely award him the most amount of money possible for aid and attendance. The takeaway from this is that it is possible for a couple to obtain approximately $24,000 of tax-free money annually to offset the vet's medical expenses. This amount of money is the difference between Joe being able to stay at home and to continue to enjoy as best he can all the creature comforts of living at home with his wife. He will not be forced to live in a nursing home because he didn't have the funds to pay for the high costs of home care. Obviously, in this video, I cannot go through all the intricacies of how the Veterans Administration calculates the amount of aid and attendance awards. Clearly, if the vet is single or if the spouse is ill, there are different rules governing how payments are calculated. But in every situation, once there is a determination made that the gross income is wiped out because of the need to pay for unreimbursed medical expenses, there will be some level of benefits granted to the vet or the vet's spouse. Of course, if the vet has too many assets, the VA will not award him anything, since the VA wants the vet to pay for care without assistance. Therefore, the asset test is the final hurdle that most vets face to obtaining aid and attendance. This hurdle can be the most challenging. Why? Because the VA says that a vet at 65 can have in countable assets $80,000. But if the vet is 85, that vet may only be able to keep $30,000. Confused? Well, welcome to my world. Now let's consider another aspect of the asset test that from my perspective might be the most vexing aspect of VA planning, and that is integrating VA benefits with benefits from another government benefit designed to help defray the high cost of long-term care, and that is Medicaid. The rules in each of these programs are significantly different. So while the VA currently has no restrictions on transferring of assets prior to applying for benefits, Medicaid certainly does. So if you give away assets for less than fair market value to create eligibility, and if that transfer was made within 5 years of applying for Medicaid, you could be in deep trouble. The cost of nursing home care is very stiff. In Palm Beach County, Florida, where I live, the average nursing home costs in a range of about $8,500 to $12,000 per month. Transferring assets outright may have been the most expedient strategy to use to obtain aid and attendance, but it may turn out to be catastrophic later if Medicaid benefits are needed to cover those high nursing home costs. Those are the eligibility criteria for aid and attendance in a nutshell. I strongly advise everyone considering applying for aid and attendance to seek out an accredited VA elder law attorney like myself before attempting to apply for these benefits. Please visit my website, lkglawpa.com, to read more about VA benefits and how they can help you and your family survive the high costs of long-term care. Also, I urge you to sign up for my free ebook primer on how the VA Improved Pension works. Please take advantage of everything you can learn about this topic on my website. When you are done digesting all of this valuable information, call or email me with your questions or comments. My staff and I are here to help. Oh, I nearly forgot. Don't hesitate to call my office to see if my services may be right for you and your loved one, and to obtain your free telephone consultation. And remember, I make house calls like that proverbial family doctor. That's why they call me Lisa Klein Goldstein, Lawyer with a Heart. Have a wonderful day.